For the court is Cumberland 2471, Gayebi versus Gayebi. Did I butcher that? Okay. We are being streamed live on the web, both by video and audio. If counsel would introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Gene Lippy, representing Loudon Gayebi.
Kenneth Altshuler, representing Omid Gayebi.
Thank you. And Mr. Libby, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, Your Honor. Front and center in this appeal is the trial court's findings, or I should say the lack of findings, that are clearly erroneous and border on callous indifference to the overwhelming corroborated evidence of physical, emotional, sexual, and economic abuse of Loudon Gayebi. Even more disturbing is the court's total disregard of the facts related to the best interest of the minor son, Taid, where the court failed to identify any factors with respect to the best interest factors supporting its decision to share equally the custody of Taid, but without a word that Loudon had relocated to New York for her job at Columbia University. The court did not mention the horrific and life-changing abuse that Loudon suffered and that impacted Taid. And there is clearly evidence in the record of that impact. The court did not mention the testimony of Susan Benjaminson, a licensed marriage family counselor, and I quote, that Loudon had a documented DSM-5 diagnosis of PTSD related to domestic violence in the marriage. There was no mention that Loudon continues to experience symptoms that interfere with her emotional and behavioral health. There was no mention that Loudon testified that Omid kicked, pushed, strangled, and forcibly against her will had sex with her in front of Omid's daughter in a Boston hotel room. There was no mention of the court's August 20th interim order where Loudon was awarded primary care. In fact, she was the only caregiver that Taid had ever known. There was no mention that Omid had only lived in the same home as Taid for 23 months out of the entire marriage. There was no mention that after overnight visitations with Taid began in 2021, he would return home to his mother and his grandmother crying uncontrollably. He was physically aggressive to his mother. He kicked, swore, and punched his mother. And he told his mother to fuck off. This is a 5-year-old. In contrast, there was no such behavior prior to the overnight visits commencing. There was no mention of Loudon's mother's testimony, Nancy Barutz, Taid's grandmother, who had lived with Loudon and Omid for almost 2 years. She was living with them between May 14th, 2014 and August 2015, and from Taid's birth on October 6th to October 9th, 2017, when both Nancy, the grandmother, and Loudon were kicked out of the house. There was no mention, this is a relocation case. There was no mention of relocation.
I see the green lights on. Can we actually take you to, you've laid out the factual basis for your appeal on those issues. Can we turn to the property issues for a moment?
Sure.
Just want to talk about Allison Avenue, the Allison Avenue property. And correct me if I'm wrong, but I understand that mortgage payments were made against that particular property during the course of the marriage. Is that correct?
That is correct.
And that would give those payments a marital component in that property. Still correct?
Also correct.
Unfortunately, though, it appears on this record, and you know it better than I do, that the amount that it was paid down, which would be the marital component, doesn't appear clearly in the record here, and so the court simply said basically, yeah, it's marital, but I don't know how much this is there. You have the burden of proof, case closed, and didn't go further with it. What's wrong with that?
Well, what's wrong with that is what I stated in the beginning. The court simply ignored the evidence.
Well, is there evidence of what the balance on the mortgage was on the
Yes.
date of the marriage?
There was evidence that on May 29th, 2013,
It was refinanced. That is a year before the marriage.
$207,500, and according to Amit's financial statement, the balance on the mortgage was $91,200 at the time of trial. So I don't know about splitting hairs, but that is a $91,200
I understand that.
documented pay down of the mortgage.
I understand that. The question is there evidence in the record of what the balance on the mortgage was on the date of the marriage? You and I may agree that it is unlikely that most of that was paid before the date of the marriage, just because that's how things work. But a judge is entitled to base their decision on evidence. And so the question is there evidence of the balance on the mortgage as of the date of the marriage, or is the closest thing we have the refinance from 2013?
Yeah, it's Defendant's Exhibit 80, which was admitted. The closest thing we have is $207,500.
A year before the marriage.
Yes, and we all know that in the first year of a mortgage, the amount of principal pay down is near zero because interest is paid first.
While that may be true on a typical amortization schedule, was that put into evidence, what the amortization schedule was on this? In other words, it is possible that someone paid, a big lump sum of $100,000 before the marriage. And in this case, what the judge said was that there was a failure of evidence, and what we need to determine is whether the evidence compelled the judge to find differently.
Well, I've pointed out those unassailable facts, that the mortgage was substantially higher and that it was paid down. And that alone is evidence of marital property. But the real issue I want to talk about in response to Judge Mead's question is the fair market value of Allison Avenue. That was owned during the marriage. My client worked in it during the marriage. There was a stipulation that Omid had materially participated in the management of the property. But you know what? He didn't fill in the court-ordered financial statement listing the fair market value at the time of the divorce. He left that blank, both in his first financial statement and his last financial statement. So what that does, and what the court said to me, well, Mr. Libby, isn't it your burden to establish an increase in value? And I said, yes. My client's financial statement shows that the property is worth $630,000. That's a $538,800 increase since from the remaining mortgage. Now, because of that omission, the deliberate omission, what the court encourages is for people to play games. And everybody knows that property increased in value. And what the court did is allow Mr. Gayebi to file an incomplete financial statement that he had to swear under oath was complete.
So the court was in a difficult spot there because the court was missing some information from Mr. Gayebi, but At that point there, can the judge simply say, okay, here's the value here, the value in her statement, therefore that reflects the increase in value, the marital component, and go with that figure there, just sort of grab it out of thin air, which on appeal, the other side would be saying, whoa, there's really no evidence here to support this number of XYZ.
Judge, you know, we can play games with numbers, as you know. The law provides that an increase in value of property acquired before the marriage is presumed marital property. The marital property presumption controls just like it does for property acquired during the marriage. So,
Counsel, on that point, is it your position that all you had to show was a pure increase in value and nothing else? Put aside the marital efforts, the marital investments, but I'm just interested in your view. Is the marital presumption dispositive of your burden at that point?
it is, because once, as I read Warren and other cases, once the party establishes an increase in value, this court has never said that you must establish a specific increase in value, but once the increase is demonstrated, the burden shifts not to my client, but to Omid to demonstrate that the increase in value is not marital property. And there is no evidence in this record, none, that there was any argument or evidence establishing that this was non-marital property. So it astounds me, quite frankly, that on this evidence, the court would say in finding of fact number 33, there was no credible evidence as to the value of the property. There was. Mrs. Gayebi's financial statement, sworn evidence, and Mr. Gayebi's deliberate omission because he knew once he put down the correct value, he would demonstrate the increase in value that he wanted to avoid. So is this what the court wants to do? Encourage gamemanship with financial statements?
Did you have any recourse prior to trial to extract that information? Was there any discovery requested, or were there any motions in limine filed?
There were motions in limine filed. There was discovery requested. There were long battles concerning discovery and the failure to produce discovery. And those are obviously much too complicated to address specifically now.
But on this issue, on this specific issue, was there a focused effort to obtain that information?
Yes, yes. I mean, I had evidence that Mr. Gayebi listed the property for sale in 2018 for $480,000. It was a listing from the multiple listing service. That demonstrated an increase in value, but the court excluded it, in my view, erroneously. And there was other testimony by Loudon of Mr. Gayebi's statements of the value of the property, and that wasn't mentioned in any of the court's findings.
Can I ask you in the 2 minutes you have remaining here, just to return for a moment regarding mortgage payments during the course of a marriage? Start with a non-marital property, but mortgage payments are made during the course of the marriage, and the party pointing out that payments during the marriage would render that portion to be marital, to be divided appropriately. Whose burden is it to show the amount of the mortgage payments that are being claimed as marital component? Is it the party, the proponent, saying this is marital, and I need to have that reflected in a division?
Well, this isn't accounting, Your Honor. The $207,000 pay down to $91,000 during the marriage, except for that first year, is in my view, more than sufficient evidence for this court, for the trial court to conclude that there was a pay down of the mortgage. Now,
The trial court agreed there was a pay down, but the trial court said that there wasn't a specific amount shown of how much it was paid down during the marriage.
Well,
Can I hone that question a little more in the remaining time? Is there
Sure.
a difference? Should we be treating, let's put it this way. If we were to disagree with you that it was up to the other party to show the specifics about increase in value, is that different than acquisition by payment of a mortgage during the marriage? Do those things rise and fall together in terms of the burden of proof? Or is acquisition during the marriage by payment of a mortgage different than a non-marital property increasing in value?
I don't think so, Your Honor.
Okay.
Because they're both controlled by the marital presumption. From the date of marriage forward, the marital presumption is that the increase in value of non-marital property is marital, just like income from non-marital property during the marriage is presumed to be marital income. I do want to mention.
Well, the red light is on, so thank you, counsel.
Good morning, judges. I've waived any need to do oral argument. I'll answer whatever questions you may have for me.
Is it appropriate in this case, when there's no question that this mortgage was paid during the marriage, the judge acknowledged that the mortgage was paid during the marriage and that there was a marital component, and that the plaintiff succeeded, that the defendant succeeded in showing that? Why shouldn't the burden then be on Mr. Gayebi, who frankly is the one in control of those finances, to parse out how much of it?
Very simple, Judge. We have a process by which you get an appraisal on the property. At any point, Mr. Libby could have requested and received an appraisal.
Well, I asked about the mortgage,
Okay,
not increase in value.
I would suggest, Judge, just the pay down of the mortgage itself doesn't necessarily translate into an increase in value during the marriage because
I
of marital
understand that,
effort. Okay.
but it is an acquisition of a marital component, is it not?
The pay down of a mortgage certainly can create a marital value to a non-marital asset.
Well, not just
Absolutely.
can, it does.
Yes.
Okay.
Well, I do the analogy about swimming
Assuming
pools.
it's paid out of marital funds and not
Well,
kept
income is
separate.
marital, so if you pay down the mortgage by your income and the other party
Right.
contributes nothing, it's still going to create
So
a
there's no
marital value.
question that at least the increase in equity paid down would be a marital component.
Correct. But remember, the mortgage payment's part interest, part principal, so the mortgage payment
understand.
itself is not necessarily.
But here, the
marital
evidence is that the principal was $207,000 on the mortgage about a year before the marriage, and it was down to, what, $91,000 at the time of this hearing. Shouldn't the judge at least have allocated that difference in the principal pay down to marital?
Well, so for example, what if Mr. Gayebi had taken a non-marital asset and paid down the mortgage by $100,000? That wouldn't necessarily make it all marital.
Why shouldn't it be his burden to show that?
Because-
If that's what happened, why shouldn't it be his burden to show that? Because that information is frankly within his control.
Well, that information could be easily procured by Attorney Libby with simple discovery. And there,
I understand it may be procurable,
Right.
but it is within his control.
right. So if you have a non-marital asset, what the law has said thus far is, if it's non-marital, it remains non-marital. If there's a marital component, the other side has to prove an increase in value because of material participation or whatever the reason
And
is.
that was proven here.
No, it was not proven because we don't know the value of the property on the date of the marriage. We know what the mortgage was. We don't know the value of the property.
We do know
Property-
what the mortgage was on the date of the marriage?
No, we do not. We could have found that out. It would have been easy to prove that. We weren't asked to do that. That's not our burden. So we established.
If I understand what you're saying, if you take a non-marital asset owned by one of the parties, and during the course of the marriage they pay down the mortgage $10,000, we'd have that figure right there.
Right.
At that point, the party claiming a marital component has the burden of showing reduction in value of or the increase in value as a result of those payments, and if they don't show that the value has increased, they get nothing for that $10,000 they paid in.
Exactly. There are things that are done to property. For example, I use the analogy of a swimming pool. Many times you put in a swimming pool and it decreases the value of the property. So simply paying down a mortgage or paying $10,000 on a mortgage doesn't necessarily mean the value of the property has gone up $10,000.
Well, it doesn't mean the value has gone up, but it may mean that the marital interest or the interest of either of the parties, whether marital or non-marital, has gone up. In other words, if you have a property that is worth $200,000 and it's got a mortgage of $195,000, and that's the state of the record before the marriage, and then during the marriage that mortgage is paid down to nothing and the property is still only worth $200,000 or maybe even worth less, is it not the marital interest though at that point?
Yes.
Even though there's been no appreciation in the value, the fair market value of the property, there is an increase in the party's interest in the property.
Equity in the property, you're correct. And equity is a marital component, but you still have to prove what that equity is, what the increase in equity is. You can't simply assume the pay down of this translate dollar for dollar. And in fact,
but we know that the property was worth at least $207,000 before the marriage,
correct,
as of the date of the marriage, don't we?
Yes, we do.
And we know that it was worth $538,000 or $630,000 based on Ms. Gaebi's statement of value, don't we?
No.
Isn't that evidence of value?
No, because she's basing that on a pure guess. We don't. First of all, she's not an owner of the property, so she by law, doesn't have the right to opine what the value is. She could get an appraisal and show that the appraisal says the value is $638,000. She just simply put a figure down in the financial statement. That is not evidence. There's no foundation for that belief.
Why didn't your client put down in his financial statement the missing information?
Well, to be quite honest with you, first, he didn't have to, but he didn't want to. His view was, I don't know what the value is. It's not my burden to prove what the value is. It's their burden. I don't want to pay for an appraisal to do that. If they want to prove a marital component, it's their burden to prove it. Why should I have to go out and pay $1,000 for an appraisal or more to help them prove their case?
Can I go to a different issue, income? In this case, the judge, first of all, completely excluded any capital gains or dividend income or profit from bartering. And I understand the raw numbers from bartering are not necessarily the profits.
Of course.
But with respect at least to dividends, I mean, your client has testified and put on his child support affidavit regular income from dividends. I mean, the amount may change somewhat, but he seems to have indicated that there was at least $7,000 or so a year. And under Section 2001-54, I mean, capital gains and dividends are indeed listed as an ongoing source. Certainly dividends are. How is that not error?
Yeah. If they're ongoing regular, then they are considered
Your
part of his
client
income.
included it in his income and said they were.
But that's a snapshot. The child support affidavit is a snapshot of income, Judge. So
But he testified that's what he lives off of, is some of the dividends and the...
that year, because he actually had gotten laid off and changed jobs, so his only income was the dividends. He had to sell stock to live on it. So that wasn't regular ongoing dividends. For example, if you had an account that paid dividends every year and it was always $7,000, that would absolutely be income. This was one moment in time that he earned X amount in dividends.
Well, it wasn't just one moment in time. I mean, it had been going on for at least a few years.
Even if it was a year or two, it would not be regular ongoing. It's just like dividends and interest.
And did he prove that he sold the stock and no longer owned the stock from which he had received dividends?
I don't believe his representation was ever challenged. That's where capital gains comes from, and dividends comes from. So
well, capital gains and dividends may come from different stocks.
that's true. Absolutely, that's absolutely correct. So
and just trading stocks may result in a gain or a loss.
but he wasn't a stock trader, so he was not. This was not his.
Well, I understand he wasn't a stock trader, but if you have a stock account, sometimes they get traded.
Absolutely, Judge.
Can I ask a funny little question? Is the ADP 401 401K the same as the Lanco retirement? It seemed like there were three different, the ADP, is that the same as the Lanco 401K?
Yes, I believe so, Judge.
Okay.
Counsel, can I go back to the financial statement
Of course.
for a moment? Did your client just leave it blank?
I believe he put to be determined or question mark unknown.
I mean, he has to sign a statement under oath that it's complete, right?
Judge, we have many financial statements where parties do not put in figures because they don't know the value.
Well, that was my question. If you know the value, you have to put it in, don't you?
Of course, he didn't know the
So
value.
by not putting it in, he's saying, I don't know the value.
Correct. And then the opponent can get an appraisal to establish the value, and that's discovery, and we do appraisals in cases all the time.
Well, was there an attempt in this case to ascertain that figure?
There was not. There was no getting an appraisal is routine, Judge. So if they requested to do an appraisal on that property, the judge we would have immediately agreed to it because it's his right to do that.
Was this a dispute during discovery to the extent that apparently two financial statements left that particular portion blank? One
No,
of,
that was
sorry,
not
one
a
of them said to be determined, and what did the second one say?
Right. So, Judge Lawrence, there was no discovery dispute about a request to value that property that we did not do. There was no request to do an appraisal on that property. We had no right to say no to an appraisal on a property. It was never requested. It was never asked. The value, anytime we were asked the value of something, I would say, we don't know the value. We're not going to get an appraisal on the property. If you want to get an appraisal, get an appraisal. It's not our responsibility. It's yours.
Can I come back to a question I asked Mr. Libby and ask you the same? What's your view of his client's burden in this case? Let's assume there was a value of a known market value of the property at the date of the marriage, and he puts that in. And he also puts in a legitimate value of the fair market value on the date of the divorce.
Right.
Is that it? Is that his burden? Does now burden shift to you to show that that was an increase due to market appreciation?
Yes. If you show that there's an increase in value of the property, that's his burden.
That's all he has to show. He doesn't have to show any marital component, any marital effort, any marital
I
investment?
do not believe so, because if the increase in value is during the marriage and my client materially participated in the management of that property, then under the Warren case, it's a marital component.
Suppose he didn't participate in any management of the property. So the evidence simply is value on date 1, value on date 2.
Then I think there's a different issue, because then if, for example, income is marital. So if you pay down the mortgage by income, it creates a marital interest. So I still think my client would have to prove that the increase of value of the property is a result of market forces and not simply the pay down of the mortgage. But the pay down of the mortgage does create a marital interest in the property. But you've got to prove, and the only way you prove it is, this is the value on close to the date of the marriage, this is the value now, that's the increase in value, okay, we know that. Part of that could be market forces, part of that could be a pay down of a mortgage. And I believe my client would have the obligation to prove what portion was market forces. I think she would have the burden of proving what portion of that was pay down of the mortgage.
Can I go to the parental rights? Obviously, the judge did know that Loudon, I'm going to use the first names, was working at Columbia and out of New York. And the judge imposed a schedule that was a 5522 schedule. Does that make any sense with one parent living in New York? We forget, aside from the schooling issue, does that make any sense for this child?
Well, first of all, Judge, I'd say she wasn't really living in New York. Throughout the proceedings, she said, I need to relocate to New York. Her parents had a home in Falmouth. There was a period of time she went to New York when there was the basement flood and there was water flooding.
Well, but then doesn't the judge have to address that? I mean, I guess I'm struggling with how I understand wanting to make perhaps a shared residence, but how, if somebody indeed is in New York for at least 3 days a week, and has to go back and forth, or may be able to bring the child, how a 5522 schedule is the right schedule for
My
this child.
assumption is it was an incentive to Ms. Gayebi to remain in Falmouth, because if you remember, the guardian's recommendation was that if she stays in Falmouth, they do a shared residency. If she does not, that primary residency is with my client. So what the court was doing is fashioning a schedule that encouraged Ms. Gayebi
Yeah, but the
to
judge
remain in-
didn't say that. I mean, that would be different if he had said, if you're in Falmouth, it'll be a 5522, but if you go live in New York, it's going to be, something different.
If I was the judge, I would have made that statement. I think clearly Ms. Gayebi had said that she's not going to leave the state of Maine without having custody of her child. I mean, she was very clear during the testimony that if the child stayed with her husband, she would remain in Maine. So the court knew that. So he fashioned, my assumption is, I hate to assume, but my assumption is the judge knew that Ms. Gayebi would not relocate if Mr. Gayebi had custody, and therefore fashioned a schedule that reflected what his overall intent was, that this child remains in the state of Maine.
Thank you.
Thank you, Judge.
And Mr. Libby, I understand you did not reserve any time for rebuttal. Thank you, counsel. As is our usual practice, we will be taking this matter under advisement and issuing a decision in due course in writing. With that, we'll be in recess on this matter.
All right.
morning. You can be seated. The matter before the court is Oxford 24-154, David Lemelin et al. Versus Construction Caterers, get on my chair here, et al. And we are being streamed live on the web, both by video and by audio. And if counsel would identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Attorney Colton Gross for the appellant David and Lisa Lemlin.
Attorney John Schulte for the appellee, construction caterers, and other individual defendants.
Thank you. And if you're ready to proceed, Attorney Gross, we'd be happy to hear your argument.
Good morning, Chief Justice Stanfill, justices, and may it please the court. My name is Colton Gross, and as you know, I represent the appellants David and Lisa Lemlin in this matter. While this is certainly a fact-intensive case, it is not a set of complex facts. On the morning of May 9, 2019, the various crew members of construction caterers arrive at 99 Mount Zircon Road in Peru, Maine, to continue the remodeling and renovations of the home that was intended to be the retirement home of my clients, David and Lisa Lemlin. They arrived, they being the various crew members of construction caterers, sometime between 7 a.m. and 8:30 a.m. Immediately upon arrival is the apparent scent of smoke. It is disputed as to whether at that time Mr. Eric Frost opened a basement door where he believed the scent of smoke to be emanating from. There's latter testimony that suggests that he did not open that basement door until closer to 12:15 when the crew hurriedly left for either lunch because they were out of materials or because Brandon Windover, another crew member, was sick. From there, at 8:30, they begin work on the home. There's another individual, Wayne Booten, who's exclusively doing work on the exterior of the home. It is disputed as to whether at this time Mr. Booten was notified as to the scent of the smoke and where they believe the scent of the smoke to be coming from. The crew then go back to work in the various areas of the home, and around 12:15, they all leave, unexpectedly, hurriedly, and shouting obscenities. This is very uncommon. This is proven by testimony via deposition and sworn affidavits. It is uncommon that the crew were to leave for lunch, ever. The crew, admittedly via various portions of deposition testimony.
Counsel, I see that the green light is on. With regard to the cause of the fire, you agree we don't know what caused this fire?
We do not know the cause and origin of the fire. That is correct, Your Honor.
And I know that you're basically arguing that some of the actions of defendants were a little bit suspicious in this case, but that does not make for proof that they caused the fire. And I know there's another theory too, but that they caused the fire. Don't you agree that you have to provide some evidence of the cause of the fire, the physical cause of the fire, in order to attach it to the defendants?
I do not, Your Honor, and that's a great question. The theory is a little bit more narrow than that. The theory here focuses in on the inactions.
Well, and that would be a difference. So you're not claiming that the defendants caused the fire?
There's no direct evidence.
I know that.
There is a significant amount of circumstantial evidence that if put to a jury could reasonably come to that conclusion.
Well, so now you seem to be saying you are maintaining a theory that they caused the fire. I understand you also have a theory about inaction in the face of evidence that there was a fire, but are you maintaining a theory that a jury could find that the defendants caused the fire?
Yes, Your Honor.
But you haven't, I read your complaint, and nowhere do you allege, directly or indirectly, that they caused the fire.
There's the specific allegations that the negligence on behalf of the defendants led to the fire. There's not.
Let me just, can you say that again?
Yes. So the
Their negligence did what for the fire?
I'm sorry, could you restate the question?
Actually, I'm trying to understand the answer you just gave. You said their negligence contributed to the fire? Something just blew back really quickly. I'm just causation, I think, there's a causation link here that is necessary for you to get, I think, to the other point in your argument. And you haven't alleged in the complaint that they caused the fire, and you're about to say, but I've alleged negligence, and their negligence did what? What did it cause?
Contributed to the cause of the fire.
How did it contribute to the cause of the fire?
That, I believe, Your Honor, gets to the kind of nuanced second portion of the argument, and that this failure to act, this whole inaction to investigate the smoke, reasonably led to the fire. Where there is
Well,
fire.
but aren't those two different theories, whether the defendants caused the fire or whether they, however the fire started? For all we know, it was Mr. Booten who started the fire. However it started, that they failed to do anything about it.
Yes, and if I understand your question correctly, Your Honor, you're parsing the two arguments.
Well, I am, because it seems to me if your theory is that they caused the fire, there has to be some actual evidence of how this fire started, and I'm going to suggest there isn't any. But that if your theory is that they failed to essentially report or contain or call for help, that wouldn't necessarily require knowing how it started, but it does require a duty on the part of the defendants.
It does indeed, Your
And
Honor.
how is there a duty on the part of the defendants to do anything?
So in this case, we would refer you back to the similar reasoning that was present in Searles v. Trustees of St. Joseph. That involved a young man playing basketball at St. Joseph, had a knee injury that was apparent to the athletic trainer. And the athletic trainer, this court reasoned, had a duty to protect that individual, and it didn't require expert testimony that the jury could have inferred, based on their knowledge, their basic knowledge, their lay knowledge, that there was a duty there incumbent upon the athletic director to appropriately inform the coach at St. Joseph's that this young man had an injury and should not be playing.
Well, the safety of a player who is part of an educational scenario, including people who are charged with a duty for the safety, is different than this here. In your complaint, I think your penultimate paragraph is 20, which is page 23 of the appendix, and you say, construction caterers owed a duty to exercise reasonable care in order to maintain the premises so as to prevent damage to the same, to inspect the premises to ensure its safety and security, and oversee the construction to avoid damage to the property. So you use the word duty, and I think that is, as we know, you're a tort lawyer, you know, in order to breach a duty of care, there must be a duty that's established by something here. Now, the relationship between these people was by contract, and I've looked at the contract, which is also in the appendix. And it's pretty bare bones. Basically says we're going to build some stuff for you. There's nothing in there. Did you argue that there's something in the contract that creates a duty?
It's again, Your Honor, if I may liken you back to Searles v. Trustees, this court, in that case reasoned that there was an oral contract between the player and the organization. This case goes a step further. We have, as you have so aptly noted, an actual written contract, even though it may be, you know, a 1, 2, 3 page standard homeowner contract that's present here in the state of Maine.
Yeah, they have a contract.
It's nonetheless a contract.
And I've gone through it word by word, but I can't find any language that creates a duty to protect the premises.
Well, there's a general duty between the contractor and the homeowner to maintain the premises.
In the contract or in the common law? Where are you getting that from?
That, I believe, would be in the common law. But
Okay.
I think my overwhelming point being that the reasoning that should be adopted here is that this contract is a contract that creates this duty. And the
Duty
case
to
law.
protect the premises?
Yes, Your Honor.
Hypothetical, if I'm having my kitchen redone, I hire a plumber to put in my new sink, and he comes there, and I'm down in Florida because the weather's too cold, and the snow is weighing down a tree that's tipping right over my porch. It's about ready to let go, and the plumber sees it on the way in. Does the plumber have a duty to call me and say, your porch is about to get bashed?
I think, Your Honor, if that were the one isolated fact, that'd be significantly different than what we have in the present matter. We have...
Okay, what makes them different? Why does the contractor have the duty in this case, but my plumber doesn't have the duty?
Well, in your hypothetical, it's an external it's a tree outside of the building that likely wouldn't be within the scope of the work of the plumber. Here we've got fire within the building that's directly within the scope of this contractor's job, which is to remodel the interior of the building. And also we have...
So if my plumber smelled smoke, then there would be a duty?
I would argue yes, Your Honor. If he is in the home, doing work within the home, and the presence...
So I can sue my plumber because my furnace blew up and burned my house down?
If he fails to investigate at all the continuous presence of smoke while you are not there, and he is conferring a benefit to you, the remodeling of your sink, I would argue yes, Your Honor.
But what's the source of that duty? What's the source of the duty? Is it just being aware of a potential danger? I mean, there's no duty to warn here. There's no special relationship, is there?
Well, there is between the contractor and the homeowner, because there's
So a contractor has a duty, a plumber has a duty. What if the guy who mows the lawn, do they have a duty? They see the house, they see smoke, they're in the vicinity. Does that impose the duty because they're getting paid to do something related to the property?
I think it would depend on the scope of the relationship between presumably a landscaper and the homeowner. Are they responsible for only the exterior premise of the home, or are they doing work within the home? Again, I think that...
So it's anybody who does work within the home has a duty to warn?
Again, given the specific facts of the case, if there are overwhelming indicators of the presence of an imminent danger, yes. If there's a one-off indication that something may be wrong, I would argue maybe not. However, that is not what we have before this case.
But Mr. Booten told somebody that it was likely the wood stove causing the smoke.
That is actually a disputed fact, Your Honor, which is another great reason that this case would have been a phenomenal one for a jury trial, such that a fact finder could make their decision as to whom they found credible with regard to those specific elements of the testimony that's present here.
If we accept your premise and rule the way you're arguing here, are we encroaching on the well-established no duty to rescue rule, which is really well established across the country here? Say, well, actually there is a duty to rescue if you're a contractor working in somebody's house.
I don't think you are, and that's a great question. And the reason I don't think you are is because this is much more narrow. This is specific to a contractor in a home when there are several instances of an imminent danger.
Well, what if the contractor is in the home and the homeowner happens to be there, which I know they weren't here, but and the homeowner's there. Homeowner slips and falls and is screaming in pain, saying, call a doctor. Does the contractor have to call a doctor? I mean, I know we would hope they would, but do they have to?
I think that falls outside of the scope of the contract to do work inside of the home. That's a fair question.
So you have to call the fire department, but not an ambulance.
I would hope they would call an ambulance. However, I think that a personal injury at the home on the behalf of the homeowner is completely distinguishable from a fire in the course of remodeling of a home while the contractor is there.
Well, in these facts, you said an imminent danger. As I understand it, there was just someone smelled smoke, not knowing what the origin of the smoke was, or the smell, I should say. And as I understand the facts, the folks from CCI had actually left the premises before there was a fire discovered.
Yep.
Am I missing something?
No, you're correct. They left the scene very quickly. And the fire occurred moments after their departure. The imminent danger being that there was a presence of smoke that we all know now led to, in fact, a fire. And had they taken the time to investigate, to do anything, to find the source, other than smell the smoke, see the smoke, and leave, it is reasonable that this fire could have been wholly prevented.
Thank you, counsel. Attorney Schulte?
Yes, thank you. May it please the Court, Chief Justice, Justices. As noted, my name is John Schulte. I represent the defendants collective.
And I note that the green light is on.
Yes, that's correct.
You've spent a lot of time talking about how they can't prove the cause of the fire. But if we were to say that the issue is a duty to act, in other words, whether they not necessarily that your clients actually caused the fire, but that they had sufficient information from which to determine that there might be a problem, doesn't that at least then present a jury question that is not dependent on the actual cause of the fire? I'm putting aside the duty question.
Well, it presupposes there is a duty.
Right.
If there's a
So
duty,
assuming there's a duty, then the causation issue, is my point, isn't necessarily, doesn't kick them out. In other words, that if there's a duty to act, and I know that's a big if, that a failure to act would arguably, at least, that there would be a dispute as to whether that caused damage, i.e., maybe it didn't, maybe the house would have burned down regardless, but at least arguably, had a fire department been called earlier, there would have been less damage.
the causation question, you're right, exactly right, Your Honor. The causation question would be different. It wouldn't be a cause and origin of the fire question. It would be a causation as to, did the failure to act actually lead to any enhanced fire damage? I mean,
So that one really turns then on the issue of duty, and they're really arguing, it sounds like that, as a contractor, there is some duty.
That's what I take the argument to be. It's plain from all the facts. There was never a cause and origin investigation. The fire department, fire marshal found that the cause of the fire was undetermined. It was accidental. There are a number of potential causes. None of them were explored. There is no cause and origin expert. There's nothing to suggest in the fact pattern that anything the defendants did, one, was negligent or in any way could have caused the fire. I think
Let's just start from the basis that there's no proof as to what caused the fire. We don't know about causation. All we know is that they smelled smoke inside a structure. An alarming concern. I mean, can we all agree that there's a moral duty that attaches when you smell smoke inside a wood structure?
there may very well be a moral duty.
Maybe?
And, well, there is a moral duty. I would agree with that.
Okay.
And that's, yes, there's
That was
a moral
the
duty.
easy part of the
You know,
question.
it goes into the, if you see something, say something. If you see something, do something. But the law doesn't impose a legal duty. And
Yeah,
that,
I think, and that's where I'm headed with my question is, there's a moral duty there, and we've said, courts across the country have said that a private citizen has no duty to warn somebody that there's a piano that's teetering, you know, on a ledge above you. They can stand back and watch it. And that's just the duty of a private citizen. But does the moral duty and the duty to warn coalesce at some point where it's actually a professional or a trade relationship between the parties there that raises it up above the level of just the individual on the street? And this is a policy question. I'm not asking you to cite any authority for this. But should we, as a court, say, no, there is a different relationship here just based upon the fact that it's a profession or a trade and an alarming circumstance that would call for moral intervention?
and I would note that that does get to the heart of this court's role in looking at fact patterns and deciding when to extend a rule or create an exception to a rule. And the general rule is there's no affirmative duty to come to the aid or protection of another person unless you cause the harm or there's a special relationship. So really, I think the question becomes looking for a special relationship. And I think the Silly case, the estate of Silly case, is one that kind of guides us on or indicates that there is no legal duty, even in the threat of potentially, someone's life being in danger, to actually take action for them.
But there is sort of a special relationship here, isn't there? Apart from the trade relationship, the commercial relationship, these homeowners have turned their house over to the contractor. They're renovating the house. The house is in the possession, so to speak, temporarily of the contractor, isn't it? And it doesn't. Wouldn't that be a potential basis for finding some sort of a special duty or relationship here?
I would say no, it does not. A business relationship has specifically, this court in, I think it was Bryan versus Watchtower Bible in 1999 said that kinship, friendship, business relationships, or organizational relationships don't give rise to a special relationship.
This is more than that, though. They're turning their house over. They're turning their property over to the possession of the contractor on a temporary basis, but it's fully in the contractor's possession, isn't it?
But whether it's their house or a building or a commercial building, a residence, a secondary residence, it's simply a commercial transaction between the parties. That's what we have at the crux here. And, this case also kind of highlights why that would be a very difficult rule to administer. Wayne Booten was there.
Well, they didn't exactly hand over the house. I mean, they said, come in and fix these things in the house. But they weren't hired to guard the house, were they?
No, they weren't. And the contract here actually has a provision on maintenance in the contract between the parties. And there is nothing at all about overseeing the maintenance or overseeing the property or the condition of the property. The maintenance provision of the contract actually deals with disposing of your materials, making sure the job site, what you do, is cleaned up. It is not about anything with respect to the overall property.
You mentioned Mr. Booten. This is sort of an aside, but on the summary judgment record, which of course we're bound by, the summary judgment record, I think there was a reference to the fact that he was residing in the house. Is that disputed?
I don't believe that's disputed. He was staying temporarily on some sort of basis at the house. He was at the house when the employees of construction caterers arrived. John Young, who's the owner, was not there that day. He was already there. There is a dispute. Did they speak to him about a fire in the morning? But that doesn't really go to the issue of whether or not there's a duty in the first place. But he was there.
I think there's a reference also that he was working with power tools, but that he tapped into the solar feed, which the owners did not give access to the construction caterers. Is that disputed, or is that in the summary judgment record?
That's the understanding of my clients.
Okay.
I don't believe that appears in Mr. Booten's affidavit. I could be wrong. I don't think he says one way or the other whether he was using the solar panel. But he was certainly drawing electricity from some source in the house. My clients, it's undisputed, they were using a generator outside to draw power in the house. But in terms of the duty, and a contractor doesn't take complete control over a house. They're there to do a task under certain hours of the day. They don't have any control as to what goes on at nighttime, when they leave. And in this case, to the extent they smelled smoke, their contention is they spoke to Mr. Booten about it. They went about doing their job.
But their presence there gives them a real heightened observation point, a heightened perspective of what's going on inside there. They may not have turned the house over to them, but does that heightened insight, again, suggest a heightened duty?
I don't believe it does. It doesn't heighten their insight into any other aspect of the house besides what their area of work is. It is undisputed that on this day they were working on the second floor. And to the extent they smelled smoke when they arrived and smelled something when they left, there wasn't really a material difference. They don't know when. We don't know how the fire started. We do know from Mr. Booten, if we take that as true, that the fire was raging about 10 minutes after they left somehow. So it does go back to just the mystery of what did happen, but really assigning a duty in a commercial transaction is something that would seem to be even less necessary than assigning a duty to come to the aid of someone who is in a life-threatening situation. After all, this is property, whether it's someone's prospective home or a commercial building. It is property. It's not someone's life that's on the line. And if you don't have a duty to act to potentially save someone's life, as was in the case of Estate of Silly, I think there have been testimony in that case that if he had made it to the hospital 10 minutes earlier, his life may have been saved. And certainly the actions of the defendant there resulted in a delay. It seemed to be much more than 10 minutes. And if that doesn't create a duty, it's hard to see where there'd be a motivation or reason to create a duty in a commercial transaction. Commercial transactions, construction cases vary in all kinds of different sizes, as this court pointed out. They vary in size from a plumber arriving to a contractor or general contractor with 15 subcontractors on site. All of that creates a really tangled mess for trying to create a duty for someone to act on behalf of another. You could have a contract, and the court actually references that or I'd referenced looking at the contract here, you could have a contract that assigns a general duty of maintenance during the project to someone. You could have a contract that says, you have complete control of this. We want you to put a fence around the area, keep people from going in while the house is unattended and you're working on it. There's a lot of terms that could have been put into the contract that could have led to the creation of a more generalized duty to maintain, but they're just not there.
You're describing the work of a general contractor, really, in other words, who was responsible for construction of the house, starting with excavation and continuing to the finish work.
Right. This is something much less than this. This is a renovation project, and it's a renovation project where two different contractors are there at the same time. Whether Mr. Booten is doing it as a friend or a contractor, it would seem to be he would have the same duty. If there is a duty, he would certainly have the same duty. He would have more of a duty, having been living there, being there overnight, someone who had, and most duties fall along the lines of knew or should have known.
So that just mean there should be a third-party complaint against Mr. Booten?
If we were going to create duties extending to all contractors, we could have a lot of interesting litigation in the state of Maine, I'm sure.
Quick factual question. In this case, you indicated that the CCI folks were working on the second floor, correct?
On this day, yes.
On that particular day. And the fire, as I recall, was commenced in the basement, or at least in the lower portion of the home, where they weren't working. Is that correct?
That is, we don't know. And because we don't know the cause and origin of the fire. So
But
there
what was discovered was flames in the basement stairway by Mr. Booten, is my understanding.
Mr. Booten had said he saw a wall of smoke. He saw flames in the basement. He saw smoke when he entered doors. Smoke was all encompassing. That would be an obvious theory to have explored. Really would have been there was a solar power station in the basement, and whether that could have been the source of an unexplained fire. That was never explored. Mr. Booten was had some power equipment that he was using. I think he denied using it that day. We had used a torpedo space heater on the second floor that day. Off and on, we said that day in the morning to heat things up. We needed it to, when we were doing the drywalling work and things like that. The defendants at various times smoked cigarettes, but we don't have any evidence in this case that there were any negligent disposal of cigarettes, negligent use of the space heater. Did the space heater have an electrical malfunction? Was it the solar power source in the basement? All of those remain complete unknowns. And even in the duty, I'm not sure what the defendants would have had to do. Having smelled, at one point, Eric Frost had mentioned that he opened the basement door and looked down just before they left and didn't see any smoke. Mr. Booten claims 10 minutes later the house is basically engulfed in flames. I'm not sure. Maybe if Mr. Frost goes downstairs, he doesn't see anything. He still smells smoke but doesn't see anything. We don't know, and that's why a duty to investigate or a duty to call the firemen to take affirmative action creates really the prospect of an unlimited liability situation, or certainly one where it's hard to define what the bounds of that liability would be.
Would that have a ripple effect across the construction industry and the insurance industry?
I'm sure it would. I'm sure it would hit the construction industry, and then if it hits the construction industry, it would hit their insurance carriers, or they would hit the construction industry back, I'm sure. That typically would have a financial consequence if that sort of duty to act on behalf of just general contractors. And here, we're dealing in Maine with a lot of local contractors. This is Peru, Maine. These are smaller folks. There actually is a 3-page contract here. A lot of these jobs are just done on a handshake. Defining what their scope or responsibility or liability would be would create a lot of headaches and problems for them.
Thank you.
Thank you.
Attorney Gross, I think you reserved 2 minutes for rebuttal.
Yes, Your Honor.
And I'm allowed to ask a question, even though I'm sure you have something to say.
Yes, sir.
Does Mr. Booten, under your legal theory, did he have a duty to warn?
He was contracted to do exclusively work on the exterior of the home.
And yet, he was actually more in control of the home itself because he was at least staying there sometimes.
I believe he was residing there maybe one night or an overnight. That is unclear. Again, I would refer back to the abundance of...
You didn't sue him, no?
No, he was contracted to do exclusively work on the exterior of the home. This is an interior issue. The smoke emanates from the interior. The scent of the smoke is present in the interior of the home throughout the day. This is where the construction caterers call the individual contractors.
Well, he was doing electrical work, correct?
He was building a deck.
But to the extent that he plugged into the solar supply source?
He did, Your Honor, and that's another disputed...
And that was interior in the basement, was it not?
The panel itself was, but there's also testimony from Caleb Getchell that they were using the outlets to charge their tools in the morning. So there's another disputed issue of fact that should be put to a jury so that the jury can, as Attorney Schulte characterized it, unravel this mystery. I believe.
But to do his work, he had to go into the house to connect his power, correct?
That I'm unsure of, Your Honor. That is unclear. I do not know if there were...
I'm guessing he used a power tool
an
or two.
external power
building
strip,
it.
perhaps. There could have been outlets on the external part of the building, I guess is my answer.
Okay.
If there's no further questions, I'll
There don't
concede the
appear
rest
to
of my
be.
time.
Thank you.
Thank you.
Thank you, and as is our usual practice, we'll take the matter under advisement, issue a written decision in due course, and with that, we are in recess over the lunch hour.
All rise.